in the case of Hezekiah Oira versus Patrick Kwaku, which is a 2017 Electronic Kenya Law report, public decision, again, amplifying the requirements on production of public documents under Section 79 all through to 82. Of the Evidence Act. This was directed in High Court at Nairobi, Civil Suit number 373, 2010, which we also wish to have the Honorable Committee benefit from the wisdom of the High Court. And from the position of the respondents, we have an obligation to assist you walk within the law. It will be a fatality if we let you go on a wild goose chase without putting pieces of law before you to assist you carry out your mandate. And we are saying the petitioner not being the maker of these documents, these being public documents, then their production must be within the confines of the law. I wish to caution the committee. I know
that is the direction we should go. Do you feel that is the direction we should go?
Most obliged.
In your clear conscience, do you feel that is the direction?
I'll go back to my submissions. Saying we have an obligation to present this before the committee so that you are well guided. I wish to also enlighten the committee that this objection at this particular time is distinguishable from our initial objection. Our initial objection was on admissibility of the documents. This is on production that is not properly suited to produce these documents. All organs of the county government are clients of the county attorney. He or she is the chief legal advisor to those entities. Therefore, the conversations between them, and particularly when you look at us, she explicitly says, I advise, I direct. They then are protected under the Section 34 of the Advocates Act. So, sorry. All the way to Section 30. All the way to Section 36, including, I think, the Evidence Act as well as the same. The Evidence Act, including, I think, the Evidence Act as well as the same. The Evidence Act, can you just confirm it for me? Of the Evidence Act, not the Advocates Act. Section 34 of the Advocates Act is about who draws what. So, comes across a document between an advocate and the client, and this party seeks to use the same document against that client of the advocate, then it becomes a violation of that privilege and the confidentiality. We pray that the production of all those documents for those reasons is declined, for them being public documents. The makers are known, the makers are alive, the makers are within the confines of the county government of Kakamega. Some of them are seated comfortably and the live stream from their offices and their phones. Otherwise, the production of these documents would compromise that confidentiality. I would refer, for example, on the letter dated 14th of April, 2023. It is, I don't know whether it remains the same, but it had been marked as DDM1, but it has been crossed out. There's a letter dated 14th of April, 2023. The very first annexure on the affidavit. There is also a letter dated of the same date to the chairperson of the County Public Service Board. There is also a letter advising the service board on the action to be taken on the decision of the Public Service Commission that they hold any action until proper directions are issued. The Chair, you will have to forgive me. I can't give you specific pages because the documentation is not marked. No pages, no paragraphs, so I can't refer you to a specific page. I can only give you the date of the documents being referred to. And that is one of the preliminary issues we were raising, which we were respectively overruled on the same. And just for clarity, on the basis for objection on those county attorney documents, it is under section 134 of the Evidence Act, which espouses the privilege of advocate and client. So we pray the Honorable Committee that you agree with us that the petitioner is not suitably footed to produce these documents, them being public documents, being uncertified, the procedure of the acquisition not being specified, the requirement for payment for these documents not having been met until the makers come to produce the same. That is all. You have to forgive. I insist. We raised the issue that the petition and the supporting documents do not comply with the rules for not being paginated. So that is why we're having difficulty referring to the sections of that voluminous document. That is all.
Counsel for the petitioner, do you have anything in response?
Yes.
Before we make a determination on it?
Yes, Honorable Chair, Vice Chair, and Honorable Committee. I will respond to the 3 points in the objection. The first one is that the documents are not paginated or arranged in an particular order. My response would be that this is a hearing and documents are being produced. And in the bundle of documents, there is a list, and that list specifically identifies the documents as appears on the list. And that's why we have said from number 1 to 18. Secondly, in the character of these proceedings, the fundamental issue is, are the respondents and their counsel prejudiced by the documents or the manner in which it is arranged? In his subsequent objections, counsel for the respondents is referring to particular documents and particular dates. So if in his objection and in addressing you, he is able to point out particular documents, it is being malicious and is misplaced. The second aspect is on production of documents by the respective authors. On that, we respond by saying, number one, that these proceedings are not subject to the provisions of the Evidence Act. The law in that respect is settled. Number two, the committee is holden to observe the Constitution of Kenya 2010, the standards therein, the County Government Act, the County Assembly's Powers and Privileges Act, and the Petitions to County Assemblies (Procedures Act) only. So that at the end of the day, what the committee should be concerning itself with is whether the respondents have been accorded their right to fair administrative action, the right to hearing. Did they have the information? Did they have the petition? Were they notified of a hearing? Are they represented? Did they participate today? And you can see clearly, Honorable Chair, Vice Chair, and members, that they are participating vigorously through council. I have not heard them say that some of those documents are ineligible, or they are mentioned in the list but missing from the bundle, or some of them are incomplete, or the substance of the documents are altered. So I think committee should overrule my colleague. The second bit on that is that in terms of the law I have cited, this committee has powers to summon officers or members who are not affected of the County Public Service Board for Kakamega, inclusive of those who will not have testified here today. The reason for that design in the law is that when you present a petition for the removal of a member or members of the board, you will be relying on official documents that are exclusively and peculiarly in the possession of the current office holders. So how would a person, given the right under Article 37 of the Constitution to present a petition, do so if the strictures of the Evidence Act were to be observed? It is for that reason that the framers of the Constitution and the legislation I have cited decided that that act will not apply. As long as you have that information, you present it to the Assembly. The Assembly then takes over. As part of its oversight, it can investigate and it can summon the staff in that board, whether affected or not, to produce documents. So as we speak, the process is not yet concluded. The committee has not downed its tools. Before determining the petition and filing a report, you still have an avenue of summoning the makers of these documents for verification. So there will be no harm. And by the way, before we go ahead, the respondents cannot stop you from doing so. So if the petitioner presents them here, you have the power to summon members of the public officers who author them to come here and verify the contents with cross-examination of the respondents. And lastly, I am now constrained to complain, Honorable Chair, Vice Chair, and members. You see the kind of time we are spending these kinds of objections. It is strictly for this reason that the design of the law does not allow strict compliance as though we are in court. The decisions which my colleague has cited, I was lucky because I served as a researcher for the Rules Committee back in the day. You will see that the decisions are on objections to production of documents in proceedings in a court of law, not a committee of an assembly. So when applying precedent, the principle in law is when you're applying judicial decisions, there's something called distinction. You distinguish. Where was the law being applied and for what purposes? The rules governing procedures and proceedings in a court of law do not apply here. So for that reason, I urge you to disregard those two decisions cited to you. And lastly, on attorney-client privilege, my colleague is mistaking his client's membership of the board with the board. For instance, when I'm writing to the assembly through the clerk or the speaker, I will address it to the speaker, but there is no property in that communication belonging to the speaker, because that office has to be held by a human being. We have not been told that the people who author those documents are complaining that their documents are being used here. And lastly, on that aspect, I invoke Article 196 of the Constitution of the Republic of Kenya and the general architecture of the law. The character of these proceedings are essentially public. The reason being, the County Public Service Board exercises powers that are public in character. You would imagine the kind of helplessness that the people of Kakamega will have if they were to be told that documents in the possession of the County Public Service Board you'll never see and you never lay your hands on. What kind of world will that be? Even you, members, how will you then discharge your mandate? If you are told you can never lay your hands on those documents, and part of the documents concern appointment to public office, and part of the documents concern use of public funds.
Finish in the next 2 minutes.
Lastly, committee members, we must make the observation that in law, the documents you're being referred to, in addition to being public, they relate to the respondents who are in office for a fixed term of 6 years. What happens when they leave office? Will they again say they'll never be used anyway? So those kinds of objections, in my view, with tremendous respect, are absurd, and that is the law intended, that they do not apply here.
Yes, Councillor Shifuka, please take a maximum of 5 minutes.
Thank you very much, Honorable Chair. With due respect, the submissions of my colleague on the last limb on occupancy of public offices and the response being public officers are myopic. It is clear that public offices are trusts which are served when the occupant is in. Once he goes, the functions continue, records continue being prepared and being maintained. So whoever takes over still takes over the same. Two, I wish to refer the committee to Article 236, Subarticle B of the Constitution. Article 236, Subarticle B of the Constitution, where it expressly protects public officers from dismissal, from punishment, removal from office, demotion in rank, through a disciplinary process that does not go along the law. It does not limit which law to be applied. You cannot say that you will not apply the law of evidence in the proceedings before the House. Why? Because your standing orders again do not provide for how have a fair chance to 1, verify, 2, test credibility, 3, verify the process of obtainment. So in the absence of that, then the respondent, it does not matter whether the advice is to an entity or an individual, for as long as it is addressed to people who are bound to take actions. In the event the advice is not taken, then those documents become privileged. It may be of interest for the committee to interrogate why these makers have not sworn any affidavits to introduce these documents. Instead, we have the petitioner. I heard him call himself honorable, who I don't know whether he was an MCA, an MP, or who, or a judicial officer. I want, in the absence of anything to waive the privilege, then they must be accorded the privilege in that form of communication and rendering advice. The custodian of these documents is not the respondents. The custodian is the secretary to the board, the AG, we have others in the executive. So by the petitioner lumping every document and saying they are the owners of the documents, it is not true. The owner is the public. And that is why there is a procedure for the public to access the documents. So far, the essence of the committee summoning witnesses is to seek clarification and have each of the parties have a fair chance to cross-examine those parties. If the petitioner is disinterested in cross-examining the makers of these documents, I wish to assure the committee that the residents are keen to have the makers properly cross-examined for the purposes of ensuring that the real issues are brought out. Maybe the petitioner has the real petitioner elsewhere, and that is why he does not care whether they are called or they are not called. Lastly, on the element of the documents, production of documents, being limited to court process, I wish to enlighten the committee and my colleague that these are quasi-judicial proceedings. The nature of quasi-judicial proceedings is that you are going to make a decision, a trial, by circumstances under which the documents were being authored. That is the dual prejudice that is bound to be suffered by the respondents. That is all, Your Honor.
Thank you, counsels. Please accord us 5 minutes, the committee, to deliberate on those issues, and then we make our directions over the same. Kindly accord us 5 minutes. Members of the gallery, please accord us some time